Good afternoon. My name is Mike Handy. I'm with the Adjudication section of our Field Services office. I've been with the division for just a little over 30 years now, and for approximately 12 years of that I've been involved with the adjudication program. I started with the adjudication program in 1985, and then I came back to it in 2009, so I've been able to see an old way that doesn't quite exist anymore, and then a new way that's transitioning into an even newer way. Today I'm going to talk about general stream adjudications, what they are, how they're conducted, and hopefully what the outcome of those will be. So what is a general stream adjudication? It's a action conducted in the district court. And also one thing I forgot to mention is the questions or the material that we covered in the exam are highlighted in red in this presentation. So general stream adjudication joins all the parties within a specific river drainage, including state and federal users along with private users and the state engineer's office or the Division of Water Rights. And this is governed under Utah Code Title 73, Chapter 4. And the first general stream adjudications occurred on the Weber, Virgin, and Sevier River basins back in the 1920s. And so this is a map that we've seen before, and it's similar to the map that shows the different area codes for the various stream basins. But as you can see from this map, every major river basin and portion of the state has been or is currently under a general stream adjudication order. So why do we conduct general stream adjudications? The first reason is to bring all pre-statutory water rights into the permanent record. And pre-statutory water rights, we've covered a little bit, include diligence claims, which is the use of surface water prior to 1903, and then also underground water claims, which represent the diversion of groundwater prior to 1935. And then something called pending adjudication claims that were prepared by our staff when they met with water users in the field to bring onto record water rights that could be diligence or underground water claims that had never been filed on. And they're pending adjudication claims because the particular adjudication effort that they were created under was never finalized by a decree. So they're something that we would look at in a current adjudication when we encounter them. It also includes bringing in the Federal Reserve rights, and Federal Reserve rights are water rights that exist or occur on federal lands that when they were reserved from the public domain. And that includes Indian reservations, national parks, forests, and monuments, and any other federal lands. And the Winters Doctrine from 1908 established that when those reservations or parks were formed, that there was an inherent water right or implied that would occur within the boundaries of those facilities or properties that would satisfy the original purpose of that park or reservation. So these water rights are not subject to non-use, and they're not dictated by point of diversion or beneficial use requirements like all other water rights are. In 1952, the McCarran Amendment went through Congress, and that waived foreign government sovereignty or federal government sovereignty from the state water law. And so that allowed these water rights to be quantified or defined through an adjudication process. And so it's a way for the state to actually be aware and plan for the water that's being utilized on federal ground as it would apply to state water law and water plans. It's also, another purpose is to prevent a multiplicity of suits, because water right adjudications can occur by water users petitioning the state engineer to help resolve a dispute, or they can be a part of a ongoing court proceeding where they're expanded to include all the water users. So ultimately you would end up with one decree over the entire area, and so that way all the issues should have been considered and taken into consideration, and so there's an understanding of how they would relate to one another. And another reason is to reduce or remove water rights that have been lost due to forfeiture through non-use. And so we've talked a lot about, or heard a lot about, forfeiture and non-use, and how needs to be a judicial proceeding that determines that. And these adjudications are judicial proceedings, and so we're kind of the arm of the state engineer that can go out and actively look for this kind of water right or the partial forfeiture or non-use. And then again, they're comprehensive and they bind all the decrees within an area. So there are 3 different phases to this adjudication process. And the green phase is the initial phase where water users are petitioned, or the water users petition the state engineer to conduct an adjudication. So then a notice is sent out to announcing through the local publications that this adjudication is about to commence. And then at that point, the state engineer schedules a public meeting in the local vicinity where the adjudication is going to be held to explain the adjudication process and answer questions prior to the work beginning. At that point, a summons is sent out to all water right claimants that have been identified in that area. And now we're in the process of actually identifying everybody who's a property owner within the area to let them know that the adjudication is coming and what can be expected of them. The next phase is the hydrographic survey, and that involves document research and field mapping and actual claim preparation. And once the hydrographic survey is completed, the water users have 90 days to submit a water user claim. Once the water user claims have been compiled and reviewed and the hydrographic survey map has been checked for accuracy, we publish what's called a proposed determination of water rights. And that's the official record of the state engineer's recommendation to the court as to the definition of the water rights that were included in the adjudication. And that's usually the part where my role ends, but now I understand this better, and we just keep moving on. But my primary focus is the production of, or making maps, assisting water users to produce claims and publish proposed determinations. Once the proposed determination has been published and distributed, there's another public meeting to explain or help water users interpret what their water rights are as they're defined in the proposed determination and to answer questions. 90 days following the publication of or once the publication is, or the proposed determination is published and distributed, water users then have 90 days to review that document and submit an objection if they have a disagreement with the way their water right appears, or if something was missed, or that type of thing. They can also object to other water rights that they may not be an owner of. At that point, during that time frame, a final summons is then published into the same vicinity to try to round up anybody that may have been missed that wasn't aware of it initially. The objections that arise from that 90-day protest period or objection phase are then reviewed by division staff and with the assistance of representatives from the Attorney General's office, and we try to resolve these protests or objections because they need to be finalized and settled prior to the issuance of the partial or interlocutory decree that would then be issued on the proposed determination. So there's a little delay on this toggle. So to go into a little more detail in the hydrographic survey, it involves researching old claims, water right records, any court decrees, property ownership records in the county recorder's office, old hydrographic survey maps from previous work, proof maps that may appear on water right files. So this is an example of an old water user claim that was filed back in the 1890s on a stream in the La Salle Mountains. And apparently they determined their flow rate by miners inches, and that's a velocity rate, and apparently that's 50 inches equal 1 CFS, so this 12 or 600 miners inches ends up being 12 CFS. So I've never seen any water rights that were quantified by miner inches. So as part of the hydrographic survey, we conduct field reviews of the areas where water rights have been identified, and that involves visiting the area, identifying the points of diversion, following stream courses and ditches, and just getting an idea of the lay of the land. And we often meet with water users in the field to discuss their uses if they weren't readily identifiable to us in our initial field work. So we spend a lot of time visiting and revisiting the same locations and meeting with people, and just kind of getting an idea of how everything relates to one another, and so we can better help prepare or work with people and assist them in preparing their claims. This is an old hydrographic survey map from the Ogden Valley up in the vicinity of Eden and Huntsville. And they represent a snapshot in time from when we've actually conducted our field survey. And so these maps were hand-drawn. I don't know if they had anything to overlay that on, or if they actually just spent an awful lot of time out there. So these maps exist in hard copy upstairs in our office in Salt Lake, and then also in the respective regional office where the adjudication has been conducted. And digital copies are also online and can be viewed through our website. And Teresa showed you a little earlier how to access the hydrographic survey maps. So as I said, this is a snapshot in time because eventually the Pineview Dam was built and the area was inundated by Pineview Reservoir. So they're kind of a nice historic artifact sometimes to see how development has changed an area. This is an example of a modern hydrographic survey map. It's an aerial photo that has polygons that have been digitized upon it. The various colors represent specific water use groups and their relationship to the irrigation that's being described. So Teresa went over water use groups, and so it's pretty tiny detail, but the white portion inside in the middle of those polygons represent the water right numbers that are used, or represent the numbers for the various water rights that are used on that ground, and then it also gives an irrigation or an acreage total by section for that use. And this map is for one section, and it has the grid pattern that Tamara described to you the other day about the northeast and northwest, and then the breakdown of the 40-acre tracts within there. And so there's a lot of information on this map. It includes points of diversion, surface courses, and any surface distribution system, as well as the irrigated acreage. That little sidebar there with the yellow line around it, that's the adjudication area, and the highlighted section shows where this section fits within that. And then there's information on the side there that identify the book name and the area that this is, along with the public land survey, section, township, and range description of where this section exists. So the next part is about water user claims. And the water user claims are completed and filed by the water user with the district court or the state engineer's office. And due to the type of information that goes on to these claims, we found that it's easier for the water user many times to have our staff compile and complete these water user claims, and then they're presented to the water user for their notarized signature as part of this adjudication process. Water users can file their own claim with the district court or submit it to our office if they choose. At the end of the proposed the compilation of the proposed determination, we submit all of the claims that we've received under the adjudication to the district court on behalf of the water user. Claims are typically only taken on perfected water rights, and that's water rights that were created during the appropriation process that have had certificates issued on them, or previously decreed water rights and underground water claims and surface diligence claims. The claim on the left dates from about my time at the beginning with the division in the mid-'80s, and then the claim on top of it is an example of what a modern day claim looks like. So these claims contain all the attributes of the water right number, owner's name, priority date, quantity, point of diversion, place and nature of beneficial use. So now we go into the proposed determination, which is the product that we produce after preparing our maps and compiling the water user claims. So the water user claims are consolidated into a concise reference, and it represents the state engineer's official record or official recommendation of the water rights within an adjudication boundary to the district court. And so the proposed determination is filed with the district court, and copies are also distributed to all of the water users within the adjudication boundary that are included within the book. Once the proposed determination is distributed, as I mentioned, there is a public meeting to review the proposed determination and answer any questions that water users may have. And so we've talked a little bit about area numbers and area codes. So this blue book is out of our Southeastern Region office. That's the Moab Division of the Taylor Flat Subdivision, Area 05, Book 3. And so oftentimes these proposed determinations are referred to as, this would be Area 5, Book 3. So most of my career has been spent in the 55 area, and I've worked on 55-2 and 55-8 and 51-5 and things like that. So that's how we refer to them, and if you refer to them that way, we certainly understand what you're talking about. And so this is an example of a page from the proposed determination. It's similar to the claim or our water right print database presentation. It identifies the water right name or the owner of the water right number, the quantity of water diverted, the priority date, identifies the source, describes the point of diversion, and also describes the place of use of irrigation by the Public Land Survey system and the 40-acre tracts that the use occurs in. And also it could include domestic use, stock watering, or any other associated uses that would fit into that. But this specific water right is for an irrigation source down in the northeast side of the Sal Mountains up along the Colorado border. So the objection phase begins after the publication and distribution of the proposed determination. So this is a slide you've seen a couple times, but this time they're fighting over their entries in the proposed determination. So if a water user disagrees with the proposed determination, they may file an objection with the district court within 90 days. These objections need to be filed with the court, and the respective court that's governing the specific general stream adjudication. And the court can also be a petition to allow a late objection. So the process works like this. You object to your representation of your water right in the district court. The objections are addressed by our staff, and we would contact the water user and see if we could satisfy them as to what the objection was, and oftentimes they'll voluntarily withdraw their objection. And so we'll reach a settlement and they'll withdraw their objection. Or they will, so either way they withdraw it or we reach a settlement, the objection is withdrawn. But if they don't withdraw their objection, they continue to negotiate back and forth between our division and themselves. Sometimes it'll end up in litigation, and so then this water right will go to court by itself. And in that process, the proposed determination is then evaluated by the judge based on questions of fact and law. And then the judge issues his decision as to how the water right should appear, and the water user either accepts that or asks for another appeal, and they just go round and round until a resolution can be resolved. So these objections need to be dealt with and resolved prior to an interlocutory decree being issued. And so that brings us to the decree phase.
Can we ask a question from St. George for just a
Certainly.
second? Well, I've got two of them. In step 1 of the adjudication process, who can request an adjudication and its extent?
To my understanding, the water users, if they have a dispute or there's some kind of issue as to how the water is being distributed or being utilized, they can petition the state engineer's office to begin an adjudication effort, or the court can order an adjudication to begin if there are existing suits and they see the multiplicity of suits and they want to consolidate that effort. Is there another?
Yes, there's one more. Is there an annual budget for state costs, any reimbursement of costs to the water right owner?
I don't understand that question. I'm not aware of any money that goes back to the water user.
Okay. If they have clarification, I'll ask them to send it.
Okay, thank you.
Thanks.
I forgot to mention that. If you guys have any questions, just go ahead and, I'm sorry I didn't mention that at the beginning. So back to our map of our river basins and, in a sense, kind of our regional boundaries also. In the early days, they did one general stream adjudication per river drainage. And so that happened on the Weber and Sevier rivers. So there's one decree on each of those systems, whereas today we would have broken that up into maybe several smaller sub-drainages to come up with a more manageable amount of water rights to adjudicate. Traditionally today we look for blocks of water rights that make sense within an area that we can define a proper boundary on, of about 800 to 1,000 water rights. So they can be adjudicated in what I'm going to refer to as a relatively timely manner. And these things traditionally take several years to get through. So this is an example of how these other areas outside of the Weber and Sevier drainages have been divided up into sub-basins or sub-drainages. And so each one of those areas would, if they had an adjudication, would have its own interlocutory decree at the end of the objection and decree phase. And so this is the same map again, but now we show where the proposed determinations have actually been created within various sub-basins within these river basins. This slide shows where we have interlocutory decrees in the dark pink, and then in the hatchered are pretrial orders, and to the best of my understanding, that's areas where interlocutory decrees are on their way to being issued, but there's been some legal work done that have prepared the groundwork for that and addressed stipulations as to how that would be resolved. If I have got that one wrong, I would refer you to maybe one of our attorneys or your own attorney for information on that, or confirmation from the podium over there. But other than that, that's where we have decrees. And this map is a little bit, that's probably up to date, although I'm I know that there's been other adjudications that have been completed, but apparently they don't have these partial decrees yet. So this is a representation of where the federal government has been joined in the adjudications. And based on the nature of these Federal Reserve rights will appear in proposed determinations where the federal government has been joined, but they are not a party to the interlocutory decree. Their water rights will be decreed once all of the sub-drainages have been adjudicated, and then they will appear in the final decree. So we reviewed the McCarran and Winters McCarran Act and the Winters doctrine that brought the evaluation of Federal Reserve rights into the domain of state court and allowed the state engineer's office to at least acknowledge them and be aware of them and incorporate them into our water use planning and water budget. So the culminating fact or a result of this is the issuance of a decree that would close the basin to assertion of any pre-statutory water rights. So this is kind of the closing of the book of these water rights that were established before water law statute came along and turned us into the appropriation and change application process where we're at now. So the fellow from Dos Equis, he doesn't always file a claim, but when he does, it's within 100 years, or it's 100 years later. So here are some frequently asked questions, and the answers are in the red. And it's, what happens if a water user chooses not to participate in a general adjudication? Will they risk forfeiture of any rights not claimed and the loss of their right to appeal or object to the proposed determination? What does it mean if the status of a water right says disallowed? So there are many reasons that that can occur, but it's generally based on the evidence of non-use or forfeiture. One of the things I look for disallowed water rights is if I can even find the described location of the original point of diversion. So oftentimes the wells are still in existence or the stream diversions are still active, but with these older water rights, oftentimes the wells have been abandoned and either they were improperly described originally or they don't exist anymore. So that's one of the flags that I look for in to beginning to think that a water right may have been disallowed through non-use. So what happens following the publication of the proposed determination? The proposed determination is distributed to the water users, objections are resolved, and the proposed determination is decreed by the district court. And lastly, a topic we didn't cover, grand juries are typically not a part of the adjudication process. So we have 2 adjudication teams. We have a relatively small staff for the work that we're tasked to perform. This is a contact information. My boss is Blake Bingham. He's the program manager. I'm Mike Handy. Josh Zimmerman is another team leader. And Chris York is a young engineer that works on our staff, and Randy Tarantino works with me. And so there's our contact information. If you have any questions about the adjudication or water rights in general, feel free to give us a call. We'll help you any way we can. So with that, I'll close for any questions the audience may have.
I just wondered if there's a place online where you can see if you have something that's involved in the adjudication, that you can kind of see where it is in the process. I know it can be really kind of a long process.
So this would be a specific water right that you have an interest in?
Well, just a city has several water rights that are tied up in the adjudication, and they've already gone through the process of the
so they would have submitted
field.
their claim?
Yes, and the claims are submitted, and they're just kind of waiting, and we just keep telling them that it takes a long time. But I just wondered if is there a place online when there's adjudications being taking place, that you can see where they are in the process? Or?
Kind of the status of the adjudication?
Yeah.
I would recommend that you contact the adjudication section, because we have a compilation of water rights where we know which ones we've received claims on or ones that are still outstanding. So it would be kind of a case-by-case basis where we could let you know where you're at during our current adjudication. When we prepare water user claims, we'll send those out to the water user, and they have 90 days to submit their claim. And so at 45 days, we send them a reminder letter. So we do our best to contact the people that we're trying to receive claims from. All right, if that's it, thank you so much for your time. I've enjoyed getting to speak to you about the adjudication. All of these topics that we've covered so far, yesterday and today, our staff are very well versed in them, and we could talk your ear off about them, but I'm glad we don't have to today. So thank you very much.